Welcome to another video. My name is Favor, and in today's video, I'm going to be breaking down one of the hardest topics in land law. If you're preparing to sit for the SQE1, especially the Functioning Legal Knowledge 2, FLK2, you'll be undertaking one of the subjects called land law and property practice. This is one topic that cuts across both subjects, and a lot of people have complained about how difficult this topic is. This came highly requested. Before I proceed, I'd first like to give a disclaimer. This is a high-level overview. You still have to undertake your own reading. Some of the things I'll be sharing are oversimplified. Without further ado, let's jump right into it. If you're living in a block of flats, think about having to move from your flat to another person's flat and having to use the hallway. The hallway is the easement. You do not own it, but then because it gives you passage to do certain things, that forms an easement. Also think about it in this way. You have a cupboard under the staircase and your neighbor allows you to store your bicycle or store certain things in the cupboard. The cupboard is not for you. So an easement is essentially a passage or an allowance in really strict and narrow sense. To break it down. Now let's go into the actual technical terms of an easement. What are the things that forms an easement? There's something called a dominant land and a servient land. When you think of the dominant land is the land that benefits from the easement. The servient land is the land that serves the servant's land. And so that's the land that is burdened by the easement. So what are the key conditions for an easement to be formed? Like we mentioned, there's a dominant land, there's a servant land. They are owned by two separate people. So the dominant land has to be owned by a separate person. The servant land has to be owned by another person. The rights must be subject matter of a grant or a reservation in narrow cases. A grant is a right that is capable of being granted. A reservation is a right that is capable of being reserved. This would make much sense when you think about you can't give an easement over a property that you do not own. So easement essentially allows you to do something on the land. There are some times that an easement prevents you from doing something, but because of the way the law sees it as you're the property owner, somebody should not prevent you from doing something on your own land. So it's interpreted really narrowly. And as at the date of filming this video, there are only 3 really narrow negative easements. That's situations where you're prevented from doing something on your land. And that's easement of light, easement of air, and easement of support. Negative easements, even though they are extremely rare and interpreted narrowly, they have to be enjoyed through an aperture, either through a window or a chimney. So think about it this way. Because you have access to light through your window, the law may, in narrow cases, prevent someone from building or doing something that would hinder your ability to actually receive light through that window. There is no easement of view, because the right to view is not subject or capable of being granted. How then can an easement be created? The first is express easement. So an express easement is created by deed, and that's where two parties come together and agree to form an easement. The next is by the operation of law. By operation of law is divided into 4 categories. So please listen carefully. The first is by common intention or by necessity. That means there is no other way to get from point A to point B. The next form of easement is an easement by prescription. An easement by prescription is formed by continuous use for a period of 20 years. An interrupted use for a period of 1 year, not exceeding 1 year, does not hinder an easement by prescription from being formed. However, there are 3 important conditions for an easement by prescription to be formed. You must have used it without permission. The owner must never have granted you that easement by permission. It must have been without any form of secrecy, and it must have been without force. So it wasn't a condition where the owner had consistently pulled barricades and you were destroying it. Remember, for an easement to be formed, there must be 2 separate owners. However, the rule in Wilden versus Burroughs is a bit different. A quasi-easement means a situation where one person owns the dominant land and also owns the servant's land. But this is what happens. That person then parts away with either the dominant land or the servant's land and still retains some part of the land. However, there are 2 main conditions for that easement to be formed. The use must have been continuous and apparent. Number 2, it must have been necessary for the reasonable enjoyment of the land. So an easement by reservation is not applicable under the rule in Wilden versus borrowers. What happens if I want to retain the rights to use an easement and I can't go under the rule in Wilden versus borrowers? Section 62 of the Law of Property Act comes in place. For Section 62 to apply, land must be transferred by deed. Section 62 can unexpectedly create new easements. It can operate without prior intention. It is often expressly excluded. So if it is not excluded, it is then read into the deed. How is an easement protected and identified? In order to know the protection that is available for easements, we need to first identify if the land is registered or unregistered, because different rules apply. We'll first start with the registered land. Express easements in registered land must be registered to be protected or given priority. If it is not registered, it would not be binding on a bona fide purchaser for value, even if the person has notice of it. That's a point that you need to know. Remember, an implied easement are the easements that are created by the operation of the law. So this could be an easement by prescription, an easement that is formed under Section 62, intention and necessity, or an easement under the rule in Wilden versus borrowers. Such easements will be seen as overriding interest under Schedule 3 of the Land Registration Act. In order for them to bind the purchaser, they must either have been used in the previous year, they must be obvious on inspection. So what happens with equitable easements under registered land? An equitable easement in registered land must be registered as a notice in the charges register. If it is not registered, it will not be binding. The rule in unregistered land is a bit simpler and more straightforward. Legal easements binds the whole world. If created expressly or created by operation of the law, it's still going to bind the whole world. And equitable easements must be protected as a Class D3 land charge. Otherwise, they are void against a purchaser for value. I know it might have been a lot, especially if this is your first time coming across this video or coming across the topic of easements. But I promise you, if you rewatch this video and you go over practice questions for the SQE, or you just go over your notes again or your textbooks, it would start to make sense. If you have any questions or you have any topic that you'd like me to film on, please let me know in the comment section. I would read them, I would make notes on them, and I would form them. And if you'd also like to get some of the notes that are formed on easements and some other SQE topics, let me know in the comment section and I will be sure to forward that to you as well. Until next time, if you've not liked this video, please like, share, leave a comment, subscribe to the channel if you haven't, and I will see you in the next one. Bye for now.